come to an end.
Well, let's see 370 then, Mullah, and see what modality is. That modality can't be to convert a legislative assembly into a constituent assembly by definition to an executive act under 367(1).
Modality out.
Then, well, we have to find the modality within the Constitution, not outside it. Not vested in an executive power of the Union. That modality cannot be. Convert a legislative assembly into a constituent. So, if your Lordship puts to me and rightly that something more had to be done under the Constitution of India, we'd like to know what is that something more. Modality within the Constitution, not outside it. Not vested in an executive power of the Union.
370 bracket 3 itself specifies the conditions.
So if your Lordship puts to me and rightly, which is the Constituent Assembly must let us know what is that something more. It must be on the recommendation of the Constituent Assembly, so it gives the solution. That is in line with the federated nature of this provision. This is complete federation, brothers. We are quasi-federal quay other states. But these are purely federal quay Jammu and Kashmir. Because the residuary powers get as well as the state. So if you say, brothers, that C70 sub-article 3 provides that solution, that is provided, certainly, but upon the recommendation of the Constituent Assembly.
And therefore, according to you, the power is completely lost once the J&K Constituent Assembly comes to an end.
Let me even not go there. If you say, brothers, that C70 there is some power right, that solution, that is provided, certainly, it's hypothetical, we're not concerned with it.
And therefore, according to you, the power is completely lost once the
Then we'll have to
J&K
take one.
Constituent Assembly comes to an end.
360 is power to amend the Constitution. That's certainly there. Now, when we look at 370 clause 3, now the issue would be whether 368 power is still available to amend the clause 2.
But your Lordship is not concerned with it in this matter.
No, it is very, very crucial because once we accept the fact now Parliament look at sovereign lawmaking body has the power to amend everything, including 368 power is still including 370.
But your Lordship is not concerned with it.
Any amendment of 370 may be subject to criticism on the ground of morality, but not power. Parliament
No, but it's not an action.
maybe it's a political argument, but not a power. It's not an argument of constitutional power.
Not action under 368. Your Lordship is not going to hypothetically say this is an action under 368 when 360 has not been invoked.
But then likewise, the exercise of power under 370 bracket 3, can it not be then criticized? It's a question of criticizing it as a political criticism. It's an argument of the absence of power. But then likewise, the court is concerned with power under the existence or the absence of power. Can it not be then criticized? It's a question of criticizing it as a political criticism.
So 368 is the power to amend the Constitution.
But we are not, are we concerned with that here? I'm sorry, brother. You require 2/3. You represent
There are independent avenue. You have the power to amend. You have the power within 370 to abrogate.
But in that independent avenue must conform to the provisions of the Constitution. Are we concerned with that here? Well, an independent avenue, the order provisions of the Constitution is no avenue at all. You represent
For the timing, if we ignore the proviso
You have the power
clause 3,
within 370
in fact, the clause 3 itself, independent of the proviso, gives the power to the President itself to abrogate 370. If we forget about the proviso.
I'm sorry to say that. I'm really sorry. There is a proviso.
Once again.
You can't exercise that power without the proviso.
No, proviso is something different. We examine the proviso independently. But independent of the proviso, if we forget
Clause
about
370 comes into play on the recommendation of the Constituent Assembly. Your Lordship is putting it the other way around. It comes on the recommendation of the Constituent Assembly that the President will exercise power, not the other way around.
But independent of the proviso.
That's why I said you can't even initiate a bill. Your Lordship will remember that. You can't even initiate a bill. Forget about anything else. It comes on the recommendation of the
Another problem is that
the
then you
President
will
will
be
exercise power.
drafting
Not the other way
the
around.
substantive part of clause 3 to postulate
That's why I said
that the
you
power
can't
and
even
the
initiate a bill.
substantive provision of clause 3 can be exercised so long as the
Can't even
Constituent
initiate a
Assembly
bill.
of J&K
Forget about anything else. It comes on the recommendation which
Another problem is that then follows the
But that's what it says, that unless that recommendation is there, you can't exercise your power. President can't exercise power under 370 of Article 3. It says so.
can be exercised so long as the
Bharat, you'll have to interpret it on its plain terms, Bharat, and your lordships have said it not once but several times over. And it's a provision which, in essence, is a provision of federalism. It's the heart of federalism, is this. It says so. Yes, it's equal. There's no doubt about it. Plain terms, I mean, whatever sophistry may happen, can't happen in this way. And it's a provision which, in essence, is a provision of federalism. It's the heart of federalism, is this. And whether 373 power, yes, has been exercised by the Constituent Assembly, saying no recommendation may happen, can't happen in this way. And I'll come to your Lordship the judgment of Sampath Prakash, which actually deals with this issue. And whether 373 power. Let's be clear, Maharaj.
Where does the Constitution specifically say that
saying no recommendation?
it doesn't,
And I'll come to your Lordship the judgment of Sampath Prakash.
the sub-article 3 will not apply to the, it only says that it only exercises three choices. Specifically says that access to the Pakistan, it doesn't, or to India, or to remain independent. Out of three, it decides that it will access to India. But where does it specifically say that it recommends that, it only says that it will be available?
Let's go back. Let's go back, fellas, to 1950, 26th of January.
But where does it specifically say?
Right? There was no Constituent Assembly. In fact, there was no decision. Originally, it was a National Assembly. There was no decision to convert it to adult suffrage into a Constituent Assembly. So Parliament, forget about the government, Parliament incorporated in 370 the provision for a Constituent Assembly. I asked my this question, why? It was a National Assembly. There was no decision. Why did Parliament do adult suffrage into a Constituent? Parliament did not. Parliament. There was no Constituent Assembly in place. Parliament. There was only a National Assembly. 70. This must have happened. I asked my this question, in collaboration with Jammu and Kashmir. Why did Parliament must have happened? Parliament. That's why the term Constituent Assembly was included in 370 sub-articles. There was only a National Assembly. 70. This must have happened. When they said in the proviso that it's on the recommendation, there was no Constituent Assembly. So it had to be a temporary provision. It couldn't be a permanent provision. There was no Constituent Assembly in place. 370 sub-articles, only a National Assembly. And the preamble of the Constituent Assembly says to further define the relationship between Jammu and Kashmir. So it had to be a temporary provision. So it was temporary because there was nothing in place. It was not temporary because this provision and the preamble had to go. No. Says to further define the relationship between Jammu and Kashmir. And therefore, Mother, that relationship was to be decided by the Jammu and Kashmir Constituent Assembly, which had to affirm all laws that had been passed. Even the laws could not be passed till such time it were ever confirmed during this period by the Constituent Assembly. So the Constituent Assembly actually was exercising a dual role, which had to at that point all laws that had been passed. And the government of India in 1950, Parliament recognized that it is the Constituent Assembly on the recommendation of which 370 would be abrogated. There would have been no constitution of Jammu and Kashmir. Let's put it that way. There would be no constitution of Jammu and Kashmir, if 370 had been abrogated. It would be yet another state of India.
Mr. Sibal, you made your point now. I think basically, as we see it, your argument is in three layers. You look at the background, the history. Look at 370 in the background.
There would be no constitution of Jammu and Kashmir, if 370 had been abrogated. It would be yet another state of India.
Interpret 370 therefore in the context of that history. Basically, and then we've gone through the background, the modalities which were followed for abrogation, which you have said that now, after having explored this terrain,
So let's
to
go
the
on
next
to the other.
where how do we now
Come back to the list of dates.
and then we've gone through the
May I, with your 2 minutes I take. There is a speech by M.A. Beg, Afzal Beg. Just it will take only
give us just the page and the gist of it, you can tell us.
694, PDF 694. It's only temporariness for us in the article. That's why that's the last person of M.A. Beg. You need not go through it. It refers to the temporary nature of the
It
article.
would be in the same vein as Mir Qasim's speech 640 years.
And Mullah, kindly note this, he was a representative of Jammu and Kashmir in India's Constituent Assembly article. That's why That's the last person. There were three members total. He was one of them. To the temporary nature of the So he was part of the Constituent Assembly of India as well. Note this: he was a representative of Jammu and Kashmir in India's Constituent Assembly. That's the last person. There were three members total. I said that a good deal of criticism was leveled in both houses of Parliament of India and in the outside press in regard to the intention of 370, that it is a temporary article and the special position of Kashmir ipso facto is of temporary nature. This raised doubts and suspicions not only in the minds of the people of the state but also in the minds of our colleagues sitting in this house about our relationship with India and Kashmir had peculiar position in 1947. It has now. That peculiar position is a permanent character of the state. It will be unfair to say that this position is a temporary nature. Statements have been made that in due course of time 370 will cease to exist and Kashmir is bound to become a Part B state. Expressions like these have in fact given rise to amendments proposed by honourable members to the statements of the Leader of the House. Some of these amendments are critical and some are unfriendly. And then he goes on to say that we did not even know that there was a note, a marginal note in this regard. This has just come up suddenly. We didn't know there was a marginal. Nobody told us that there'd be a marginal note of the Leader of the House. Some of these amendments, that's all that he says. I just wanted to invite my Lord's attention. Then he goes on to say that we did not even know. So in my supplementary submissions, only I have set out these passages, nothing more than that. Nobody told us that there'd be a marginal note. And so last time, so long as it is not completed, Article 370 will remain there. And when it reaches completion, we shall give to Paul what Paul's and what he gives to Peter what Peter. This is the center. That is, center will have the exceeded subject and the rest will remain here. 370 will have to be accordingly altered. It would not mean that Kashmir state will cease to have its special position. Amending 370 may be necessary at the time when we finalize our constitution. But even then, legally, constitution as it cannot in any way rob Kashmir of its special privileges given to it by common agreement. 370 is therefore temporary till we complete our constitution. That's the spirit with which it was incorporated in the constitution. Then, legally, this is the point in any way. Rob Kashmir of its special privileges. Anyway, Malad, that's I've done with it. It's not kindly come back to you therefore temporary till we complete our constitution. That's the spirit with which it was incorporated. We were at the constitution. Then, legally, this is the point in any way. We were at serial 71 in written submissions, compilation volume 2,
prosecutors.
PDF 53.
What the Biden administration is trying.
Be asking for the judge to recuse herself
Serial
as
number 72.
Yes, serial number 70. We were at serial 71 in written submissions, compilation volume. Let's read 71, 3rd of August.
What the Biden administration is trying.
be asking for the judge to recuse herself
Serial
as
number 72.
Yes, serial number 70. The governor of the state of Jammu and Kashmir, my lord, PDF letter 853, page 53 also.
Administration is trying.
be asking for the judge to recuse
Justice Paul, my lord,
herself
has
as
it.
Yes, that's why I said serial number 72, 5th August.
71, brother, I just The want to read governor of the 71. state of Jammu and Kashmir, my lord, governor of the state of Jammu and Kashmir gave a press statement on the night of 3rd of August that he was not aware of any proposals to amend 370 or Article 35.
Serial number 72, 5th August.
And that all security arrangements and reinforcements of the state were being made pursuant to intelligence reports forecasting a major terror incident. Gave a press statement on the night of 3rd of August. On the 5th of August at 11 a.m. On August 5, the President issued the impugned order, all security titled the Constitution Application to Jammu and Kashmir Order 2019. This is CO 272. So that's therefore marked. It's an executive act. On the 5th of August at 11 a.m., the said order issued under Article 371 with the purported concurrence of the government of the state of Jammu and Kashmir inserted Article 367(4) of the Constitution of India. So that's what the said order issued under Article 272 with the purported concurrence of the government of the state.
তিন
In
ফিলিস্তিনিকে
particular,
গুলি
the
করে
newly
হত্যা
inserted Article 367(4)(c) stated that references in the Constitution to the government of the state of Jammu and Kashmir would be construed as including references to the governor of Jammu and Kashmir.
तीन फिलिस्तीनी के गुली को
newly inserted article, further 367(4)(d) amended subclause 3 of Article 370 by replacing the expression Constituent Assembly of the State with the Legislative Assembly of the State. Executive Act.
तीन फिलिस्तीनी के
Now let's come and look at that. Further 367, it's in volume 3, amended subclause 3 of PDF page 101. Replacing the expression Constituent Assembly of the State with the Legislative Assembly. Executive Act. Of documents. Now let's come and look at that.
101.
It's in volume 3.
As you can find.
Page 494. Of documents. Let's come and look at that. Now kindly note, Malad, at this point in time, 356 was in operation. 493. Volume 3. Documents, volume 3. PDF page 101. Note, Malad, at this time, 356 was in operation.
5th August 2019 notification.
That's right. Volume 3. Documents, volume 3. PDF page 101. Note, Malad, at this time, 356 was in operation.
5th August 2019 notification.
That's right. Volume. In exercise of the powers conferred by Clause 1 of 370 of the Constitution, the President, with the concurrence of the government of the state of Jammu and Kashmir, could never be done. Because other than 92, 36 and 38, Governor could only act on the aid and advice of the Council of Ministers. By Clause 1 of 370 of the Constitution. That's the Jammu and Kashmir Constitution. With the concurrence of the government of the state of Jammu and Kashmir, could never be done. Because other than 92, 30, the governor could not represent the state. Governor could only act on the aid and advice of the Council of Ministers. By Clause 1 of 370 of the Constitution. That's the Jammu and Kashmir Constitution. With the concurrence of the government of the state of Jammu and Kashmir, could never be done. Because other than 92, 30, the governor could not represent. So the very inception, governor could only act on the aid and advice of this executive order is constitutionally flawed. With the concurrence of the government of the state of Jammu and Kashmir, could never be done. Because other than 92, 30, the governor could not represent. So the very inception, governor could only act on the aid and advice of this executive order is constitutionally flawed. In exercise of the powers conferred by Clause 1 of 370, the President, with the concurrence of the government of the state of Jammu and Kashmir, is free to make the following order. This order may be called the Constitution Application to Jammu and Kashmir Order of 2019. It shall come into force at once, which shall thereupon supersede the Constitution Application to Jammu and Kashmir Order 1954, with all amendments thereafter was present before order, as amended from time to time. All the provisions of the Constitution as amended from time to time shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply shall be as follows. So, to Article 367 shall be added the following clause. 4. For the purposes of this Constitution as it applies in relation to the state of Jammu and Kashmir, reference to this Constitution or to the provisions thereof shall be construed as reference to the Constitution or the provisions thereof as applicable or as applied in relation to the state. Reference to the person for the time being recognized by the President on the recommendation of the Legislative Assembly of the state as Sadr-e Riyasat of Jammu and Kashmir, acting on the advice of Council of Ministers of the state for the time being in office, shall be construed as references to the Governor of Jammu and Kashmir, and references to the government of the state shall be construed as including references to the Governor of Jammu and Kashmir, acting on the advice of the Council of Ministers. How can that be? There is no Council of Ministers. So you create a constitutional myth of Jammu and Kashmir, and references to the government of the state shall be construed as including references to the Governor of Jammu and Kashmir, acting on the and assume in the absence of Council of Ministers that there is a Council of Ministers. And then you pass a presidential order that even in the absence of Council of Ministers, the Governor is acting on the aid and advice of the Council of Ministers.
اختتم اجتماع مستشاري الأمن الوطني لأكثر من 40 دولة ومنظمة دولية بشأن الأزمة الإقليمية التي انعقد يوم أمس في جدة، واتفق واتفق المشاركون في هذا الاجتماع على
You wanted
أهمية
to do something, you
مواصلة
did it.
التشاور الدولي وتبادل الآراء بما يسهم في بناء أرضية مشتركة تمهد الطريق للسلام. كما أعربوا عن أمس في جدة واتفق المشاركون في هذا الاجتماع على أهمية
I don't think in any constitutional democracy in the world this has happened.
الآراء بما يسهم في بناء أرضية مشتركة تمهد
In the famous Miller case in the UK, Boris Johnson tried to bypass Parliament and requested the Queen to prorogue the House. The House was prorogued. In the famous Miller case, immediately Miller's matter came to the Supreme Court. All the justices of the court sat. Miller's, Your Lordship knows this is the executive power of the government. They can prorogue the House. But all came to a unanimous decision. The House was prorogued. You cannot even prorogue the House like this. You cannot exercise executive power to bypass Parliament. You bypass discussion in Parliament. They can prorogue the House. That's not the way constitutional democracies work. And this is much worse. You cannot even prorogue the House. You assume something that doesn't exist. You give powers to the governor which he does not have. You bypass discussion in Parliament. You assume to yourself under 350 all the powers of the state legislature. You are Parliament, so you therefore invoke the powers of the state legislature and Parliament and pass an executive order. What kind of you assume to yourself under 360 exercise of law is that constitutional law? And then D, in the proviso to clause 3 of Article 370 of this Constitution, the expression Constituent Assembly of the state referred to in clause 2 shall be the Legislative Assembly of the state. What power does the President have to pass such an order? And then D, we're not dealing here with exercise of constitutional power. We're dealing with exercise of executive power. Referred to in clause 2 shall be the Legislative Assembly of the state. What power does the President have to pass such an order? And then D, we're not dealing here with exercise of constitutional power. We're dealing with exercise of executive power. Referred to in clause 2 shall be the Legislative Assembly of the state. What power does the President have to pass? Are you? We're not dealing here with exercise of constitutional power. We're dealing with exercise of executive power. Are you? We're not dealing here with exercise of constitutional power. We're dealing with exercise of executive power. Are you? We're not dealing here with exercise of constitutional power. We're dealing with exercise of executive power.
महोदय, मैं प्रस्ताव करता हूं कि दिल्ली राष्ट्रीय महोदय, मैं प्रस्ताव करता हूं कि दिल्ली राष्ट्रीय महोदय, मैं प्रस्ताव करता हूं कि दिल्ली राष्ट्रीय
आज संसद के अंदर दिल्ली के
महोदय, मैं प्रस्ताव करता हूं
उसको कोई काट आज संसद के अंदर दिल्ली के
महोदय, मैं प्रस्ताव करता हूं
उसको कोई काट आज संसद के अंदर दिल्ली के
महोदय, मैं प्रस्ताव करता हूं
उसको कोई काट आज संसद संसद के अंदर दिल्ली के उसको कोई काम आज संसद के अंदर दिल्ली के उसको कोई काम आज संसद के अंदर दिल्ली के उसको कोई काम आज संसद के अंदर दिल्ली के उसको कोई काम आज संसद के अंदर दिल्ली के उसको कोई काम आज संसद के अंदर दिल्ली के उसको कोई काम आज संसद के अंदर उसको कोई काम
आज क्या कहना चाहेंगे आप? काफी दिन हो गए काम देखिए आज क्या कहना चाहेंगे आप? काफी दिन हो गए काम देखिए आज क्या कहना चाहेंगे आप? काफी दिन हो गए काम देखिए
Just as a test, from their perspective, why was the amendment to 367 necessary at all? Why was this crucial? I mean, we are seeing now the modalities which they have put into place. For their constitutional design of ultimately abrogating 370, why was this amendment to 367 from their perspective?
Because they themselves gave the power of the Legislative Assembly, which they were exercising in 356 as the Constituent Assembly, and recommended.
For their constitutional design,
They were ad item of my interpretation. They were ad item of my interpretation.
They constituted the Legislative Assembly as a constitution.
They say in proviso 3 of 370.
ताओ रखेंगे, क्योंकि आधिकारिक तौर पे उन्होंने किया है, अब रखेंगे और उसके बाद आगे की कार्यवाही होगी। सीधे चलते हैं, सोनिया गांधी भी पहुंच चुकी हैं, तमाम नेता पहुंच चुके हैं और अब सीधा आपको ले चलते हैं कि थोड़ी देर बाद राहुल गांधी को सुनेंगे हम। उससे पहले लोकसभा की कार्यवाही में क्या कुछ हो रहा है, चलिए जरा सुन लेते हैं, देख लेते हैं, सीधा चलते हैं। रखेंगे और उसके बाद आगे की कार्यवाही होगी। सीधे चलते हैं, सोनिया गांधी भी पहुंच चुकी हैं, तमाम नेता पहुंच
आदरणीय अध्यक्ष महोदय, आपके निर्देश से आज की संसद कार्य सूची में क्रम संख्या 2 पर मेरे नाम के सामने
लोकसभा की कार्यवाही में क्या कुछ हो रहा है, चलिए
Item number 3 required the definition of the assembly of 370 as legislative assembly. This is why they could exercise power.
But suppose for a moment that they have not gone through this exercise of or existing 367 and suppose they are operating purely within the fold of but suppose for a moment now just testing it as an exercise of power under 356. Once the proclamation takes place under 356, two consequences follow. One, the President assumes to herself all the powers of the state, the executive powers of the state rest in the President, an exercise of power under 356. Except the legislature, the powers of the state legislature. Two, the powers of the state legislature are then subsumed in Parliament. The government of India does not in its executive capacity exercise the powers of the state legislature. Parliament has to exercise the powers. So once the proclamation under 356 was issued, two consequences would follow. All the powers which were vested in the executive of Jammu and Kashmir were transferred to the President. All the powers of the state legislature were vested in Parliament. Now, if that was so, then if 370 bracket 3 is capable of the interpretation, just the hypothesis, that it's a power to be exercised by the President to abrogate. State legislature, they abrogate. Point number 2, any powers which were to be exercised by the state legislature would have to be exercised by Parliament. So they had to go to Parliament to get a resolution passed. Why was 367 necessary for the design, for the constitutional design to achieve this at all?
I tell you, 356 power cannot be exercised by Parliament, by the governor, by the President and Parliament in this fashion, independent of 367. Cannot be done. Because you are only acting as the legislature. You don't have any powers independent of the legislature under 356. That's Bomai has held that. You have no such power. And the executive is only dealing with administration. It can't amend the constitution under 356. Therefore, they had to do this. There was no choice. You don't have any powers. I'll show Bomai under 356. That's Bomai has held that.
Yes. But assuming for a moment that we sort of, suppose we disregard the 367
constitution under 356. Even if you do, then you can't exercise it under 356 at all. It's even, it will be a dead letter. I'll show the inchoate. Under 356, that's Bomai has held that. Because you can't amend constitutional provisions through 356. You can only exercise the power of the state. Parliament can do it.
Fair enough. Therefore, that part of the notification which amends 367 is kept aside for a moment. Then what is the consequence?
The consequence is that 356 power cannot be exercised. You can only exercise the power of the state to achieve the same result. Parliament can do it.
Fair enough. 356 power, that part of the notification is the power of the state legislature and the state executive, which is now being vested in the President and in Parliament, respectively. You may be right for a moment, subject to hearing them, that look, how can you exercise the power to amend the Constitution by taking recourse to 356? Fair enough, we got that point and we'll hear them on that. But assume that we disregard this whole process of what took place under 367 for a moment, subject to hearing them. Either disregard it or hold that it was constitutionally impermissible. Even so, does it affect?
That's a separate issue. I'll address your lordship on that. At the moment, I'm on this executive order. I'll come to 356. I'll come to the other issues later. Because ultimately, what you then do is Parliament is exercising power as a legislature, and Parliament is exercising powers under 356 as well. Correct, Manoj? And as a legislature of the state, let's assume, the state had to convert itself into a constituent assembly in terms of 373. As a legislature,
I think what they believed was they proceeded on a particular hypothesis
as well.
that consultation with the Constituent
And as a
Assembly is
legislature of the
necessary.
state,
So therefore, they said that all right,
the
we are now
state
going
has
to
to
replace the
convert
word
itself into
Constituent
a
Assembly by
constituent
the word
assembly in terms
Legislative
of
Assembly,
370.
which they sought to achieve by amending. I think what they believed was they
Recommendation of the constitution is not just converting it as well. You can't
the first step was to amend the
And as a legislature, you recommend it to yourself because you have a political objective to recommend it, and mother, you take the decision yourself.
Yes.
These are very problematic, mother. And see the consequences of this. That means through an executive order, you can change any provision of the constitution. Because you have majority. Objective to recommend it, and this majoritarian culture cannot destroy the edifice of what our forefathers gave us. That means through an executive order,
So
you
your
can change
argument
any provision
therefore
of
is
the
that
constitution.
you cannot exercise the power
Because
under
you have majority
356 to amend the Constitution. That point you
We cannot possibly justify it unless there is some new jurisprudence that comes to light that they can do what they like as long as they have the majority. As it is, Mullah, now one of your esteemed colleagues has said, Mullah, that in fact basic structure, those theory is also doubtful. Maybe it is.
If we refer to a colleague, we have to refer to a sitting colleague.
They can do what they like as long as they have the majority.
Once he seems to be judges, they are not binding dictate.
Of course it's not binding, but I'm surprised that
On
basic
11th of November
structure, those theory is
19th,
also doubtful.
Parliament doesn't discuss what goes on in the court.
No, I'm not discussing anything. I am
Not discuss what goes on in Parliament.
No, I'm not
And
discussing.
everyone, my lord, has a freedom of
This is a public view.
freedom of expression.
No, I know. Malad, I assume he has the freedom of expression, what he likes. I don't dispute that. I'm just saying, Malad.
What goes on in the court.
No, I'm not discussing anything. Absolutely.
Not discuss what goes
We're starting a debate on that because of this majoritarian culture again.
freedom of expression.
No, I know. Malad, I assume he has the freedom of expression, what he likes. I don't dispute that. I'm just saying, Malad. I said that 356 is already in place. We're starting a debate on that because of this majoritarian culture again.
Freedom of expression.
No, I know. Malad, I assume he has the freedom of expression, what he likes. I don't dispute that. I'm just saying, Malad. I said that 356 is already in place. We're starting a debate on that because of this majoritarian culture again.
Freedom of expression.
No, I know. Malad, I assume he has the freedom of expression, what he likes. I don't dispute that. I'm just saying, Malad. I said that 356 is already in place. We're starting a debate on that because of this majoritarian culture again.
Freedom of expression.
Malad, I assume he has the freedom of expression, what he likes. I don't dispute that. I'm just saying, Malad. I said that 356 is already in place.
Mr. Sibal is responding to the parliamentary debate here because possibly he was not there in the parliament yesterday.
That is true. That is absolutely true.
It was that place where he could have learned,
You are right.
expressed
You're right.
his views on basic
No,
structure.
not my view. I'm not, my
Sibal
view
is
is clear
responding
because
to
my
the
view is the
parliamentary
court's
debate
view.
here
I can't go
because
beyond that.
possibly he was not there in the
But I am an
parliament
officer of the
yesterday.
court. That is true. In court, I have that constitutional view. Outside may have a
That place
different
where he
view.
could have learned,
You are right.
expressed
You're right.
his views on basic structure.
Anyway, that's neither here nor there. It's just an aside. My view is clear because there must be some element of, but I am an officer of the court, humor and mirth in court as well. That constitutional view. Not everything can't be this serious. Therefore, see the consequences of this. And whether then it is obviously clear that the government of India and Parliament recognized that the Legislative Assembly was the Legislative Assembly and could not be the Constituent Assembly. Well, this is my interpretation. Therefore, see the consequences of this. And whether then before it became necessary, because they also knew that the Legislative Assembly can't be the Constituent Assembly. That's precisely what I've been arguing, was the Legislative Assembly and could not be the Constituent Assembly. Well, this is my interpretation. Therefore, see the consequences of this. And whether then before it became necessary, because they also knew that and it says shall read. This is an interpretation clause. Precisely what I 367 is an interpretation clause. It's not a clause to substitute definitions. If you look at 367, the heading is interpretation. Because they also knew, and it says shall read. This is an interpretation clause. It's not substitution. You can't substitute definition. It's not a clause to substitute definitions. You can only interpret. 367, the heading is interpretation. So it's outside of 367 itself, apart from many other things that I've pointed out. It's not substitution. You can't substitute definition. It's not a clause to substitute definition. You can only interpret. 67, the heading is interpretation. So it's outside of 367 itself, apart from many other things that I've pointed out. It's not substitution. You can't substitute definition. It's not a clause to substitute definition. You can only interpret. 67, the heading is interpretation. So it's outside of 367 itself, apart from many other things that I've pointed out. It's not substitution. You can't substitute definition. It's not a clause to substitute definition. You can only interpret. 67, the heading is interpretation. So it's outside of 367 itself, apart from many other things that I've pointed out. It's not substitution. You can't substitute definition. It's not a clause to substitute definition. You can only interpret. 67, the heading is interpretation. So it's outside of 367 itself, apart from many other things that I've pointed out. It's not substitution. You can't substitute definition. It's not a clause to substitute definition. You can only interpret. 67, the heading is interpretation. So it's outside of 367 itself, apart from many other things that I've pointed out.
धूल, मिट्टी, HD पसीना, इंस्पिरेशन आता है तो सिर्फ इनसे।
मणिपुर का युवा इंसाफ मांगता है, मणिपुर की बेटी इंसाफ मांगती है, मणिपुर के किसान इंसाफ मांगते हैं, मणिपुर के छात्र इंसाफ मांगते हैं। और मार्टिन लूथर किंग ने कहा है, मार्टिन लूथर किंग ने कहा है कि अगर कहीं भी मणिपुर का युवा इंसाफ मांगता है, ना इंसाफी हो, मणिपुर की बेटी तो वो हर जगह के लिए मणिपुर के किसान इंसाफ का खतरा बन सकता है। मणिपुर के छात्र इंसाफ मांगते हैं। और मार्टिन लूथर किंग ने कहा है, मार्टिन लूथर किंग ने कहा है कि अगर कहीं भी मणिपुर का युवा इंसाफ मांगता है, ना इंसाफी हो, मणिपुर की बेटी तो वो हर जगह के लिए मणिपुर के किसान इंसाफ का खतरा बन सकता है। मणिपुर के छात्र इंसाफ मांगते हैं। और मार्टिन लूथर किंग ने कहा है, मार्टिन लूथर किंग ने कहा है कि अगर कहीं भी मणिपुर का युवा इंसाफ मांगता है, मणिपुर के किसान इंसाफ का खतरा बन सकता है। मणिपुर के छात्र इंसाफ मांगते हैं। और मार्टिन लूथर किंग ने कहा है